Good day, we will be discussing the Week 15, Reformation of Instruments and Rexable Contract, Article 1359, Reformation of Instruments. If parties agreed but the written contract does not express their true intention because of mistake, fraud, inequitable conduct, or accident, the court may order reformation. If there was no real agreement, the remedy is annulment. Example 1. S sells land to B including the house, but the deed says land only. The court may reform the deed to include the house. Example 2. Two businessmen agree to a loan contract with 10% interest, but the written document mistakenly says 1%. Either party may ask the court to reform it to reflect the true terms. Article 1360, General Law Principles. The Civil Code adopts the general rules on reformation of instruments, but only if they do not conflict with its provisions. In case of conflict, the Civil Code provisions must always prevail over general law. Example 1. Courts may apply general principles to interpret contracts, but the Civil Code rules always prevail. Example 2. If foreign rules on reformation differ from the Civil Code, the Civil Code's provisions will control in Philippine courts. Article 1361, Mutual Mistake. If both parties made the same mistake about a fact, and because of it the written contract fails to show their real agreement, the court may reform the instrument to make it conform to what was actually agreed. Example 1. S and B agreed the horse silver was sold, but the deed mistakenly says golden. Example 2. Two parties agree on the sale of 500 square meters of land, but the deed of sale incorrectly states 5,000 square meters. Reformation is proper to show the real agreement. Article 1362, Mistake plus Fraud. When one party signs by mistake and the other party acted fraudulently or unfairly so that the document does not show their real agreement, the innocent party may ask for reformation. Example 1. A seller agrees to $500,000, but the buyer tricks him into signing $50,000. Example 2. A landowner intends to sell only half of his property, but the buyer secretly drafts the deed to cover the entire property. The seller may ask for reformation. Article 1363, Concealment of Mistake. If one party realizes that the written contract is wrong but hides this fact from the other party, the injured party may ask the court to reform the instrument so it matches their real agreement. Example 1. Buyer sees that the contract states a smaller land area than agreed but does not tell the seller. Article 1364. Error by drafter. When the written contract does not reflect the party's real intention because of ignorance, lack of skill, negligence, or bad faith of the drafter, typist, or clerk, the parties may ask the court to reform the document. Example 1. A typist writes Lot 5 instead of Lot 6. Example 2. A clerk mistakenly types 100,000 instead of 1,000,000. Article 1365. Mortgage or pledge written as sale. If the parties really intended a mortgage or pledge, but the contract mistakenly states that the property was sold, the court may order reformation so the contract shows the true nature of the agreement. Example 1. Parties agree to mortgage land, but the document states an absolute sale. Example 2. A borrower pledges jewelry as collateral for a loan, but the document says the jewelry was sold. The contract may be reformed. Article 1366. Cases where reformation not allowed. Reformation cannot be done in certain cases: when the contract is void from the start, when it involves wills, or when the contract has already been fully performed. The law sees no reason to reform documents in these situations. Example 1. A will with mistakes cannot be reformed. Example 2. A donation without conditions that was poorly worded cannot be reformed, since the donor gave it freely. Article 1367, Action to enforce bars reformation. If one of the parties has already filed a case in court to enforce the written contract, that party can no longer later ask for reformation of the same instrument. Example 1. Buyer sues to enforce a deed of sale, then later asks to reform it. This is not allowed. Example 2. A tenant files a case to enforce a lease, but after winning claims the lease term was mistaken. Reformation is barred. Article 1368, Who may ask for reformation? The right to ask for reformation belongs to the parties to the contract, and in case of their death or transfer, their heirs or successors may also file for reformation when they are affected. Example 1. An heir corrects a contract signed by his parent. Example 2. A corporation's successor in interest files for reformation of a supply contract inherited from its predecessor. Article 1369. Procedure reformation is not automatic. It can only be obtained by following the proper process through the courts under the rules of court. Example 1. A buyer files a petition in court to correct a deed of sale.
Article 1380. Rescissible contracts. Contracts that are valid and complete may still be rescinded by law when they cause damage or unfairness to a party, or even to a third person. Example 1. A guardian sells a ward's land at a very low price, causing great loss. The sale is valid but rescissible. Example 2. A debtor transfers his only property to avoid creditors. The sale is valid but can be rescinded by the creditor. Article 1381. Cases of rescissible contracts. The law lists certain contracts that may be rescinded, such as contracts by guardians when the ward suffers loss of more than 1/4 the value, contracts made for absentees with the same kind of loss, contracts made to defraud creditors, contracts over property under litigation made without court approval, other contracts declared rescissible by law. Example 1. A guardian sells a miner's land worth $20,000 for only $10,000. The contract may be rescinded. Article 1382. Payments in insolvency payments made by an insolvent debtor for debts that are not yet demandable or cannot legally be demanded may be rescinded. Example 1. An insolvent debtor pays a loan that is not yet due, leaving nothing for other creditors. The payment may be rescinded. Article 1383. Subsidiary remedy rescission can only be used if there is no other legal way to repair the damage caused by the contract. Example 1. If a guardian sale causes damage but the loss can be repaid in money, rescission is not needed. Example 2. If a creditor can recover his claim through execution of other property, rescission cannot be used. Article 1384. Extent of rescission. Rescission should only cover the part necessary to repair the damage. The whole contract is not cancelled if partial rescission is enough. Example 1. A guardian sells 2 properties worth $200,000 each for a total of $200,000. Only one sale may be rescinded to cover the loss. Article 1385. Effects of rescission. When a contract is rescinded, both parties must return what they received, including fruits and interest. But rescission is only possible if the one asking can also return what he got. If the property is already in the hands of an innocent third party, rescission is barred, but damages may be claimed. Example 1. A miner rescinds a sale of his land sold too cheaply. He must return the money with interest, while the buyer must return the land with its fruits. Article 1386. Court-approved contracts. Contracts made for wards or absentees that were approved by the court cannot be rescinded even if they cause loss. Example 1. A court approves a guardian's sale of land at a low price. The sale cannot be rescinded. Example 2. An absentee's property is sold under court order. Even if the price is less than fair value, rescission is barred. Article 1387. Presumption of fraud. A debtor's contracts that transfer property may be presumed fraudulent in some cases. Gratuitous transfers, donations, leaving no property to pay debts. Onerous transfers, sales, made after a judgment or attachment against the debtor. Example 1. A debtor donates land to his son while leaving unpaid debts. This is presumed fraudulent. Example 2. A debtor sells land after a judgment is issued against him. The sale is presumed fraudulent against creditors. Article 1388. Liability of purchasers in bad faith. Anyone who acquires property in bad faith from a debtor who acted in fraud of creditors must return it or pay damages if return is impossible. Example 1. A debtor sells his car to B to defraud a creditor and B knows about it. If rescinded, B must return the car or pay damages. Article 1389. Prescriptive period. The action to rescind must be filed within 4 years. For minors under guardianship, the time starts when incapacity ends. For absentees, the time starts when their domicile is known. Example 1. A ward discovers at age 21 that his guardian sold land too cheaply when he was 15. He has 4 years from age 21 to sue. Summary. Reformation of instruments is a legal remedy used when a written contract does not express the true intention of the parties due to mistake, fraud, accident, or unfair conduct. The contract itself is valid, but the document may be corrected by the courts to reflect what was really agreed upon. However, reformation is not allowed in wills, simple donations without conditions, or void contracts.
Resciscible contracts, on the other hand, are valid and effective, but may be set aside by law when they cause damage or unfairness to one of the parties, or to third persons, such as minors, absentees, or creditors. Rescission is a subsidiary remedy, available only when no other legal action can repair the damage, and its effect is mutual restitution of what was exchanged. Thank you for listening. To check your understanding of today's discussion, we'll now have a short Q&A. We've prepared some simple questions related to the articles we explained. Feel free to answer. And don't worry, this is just to review and reinforce the key points of our topic.
1. Which of the following contracts cannot be reformed under the Civil Code? A. A conditional donation. B. A mortgage written as a sale. C. A will. D. A contract with typographical errors. 2. What is the effect of rescission under Article 1385? A. Both parties must return what they received, including fruits and interest. B. Only the injured party returns what he received. C. The contract is cancelled, but no restitution is required. D. The parties keep what they received, but pay damages.
3. What best describes a resciscible contract? A. A contract void from the start. B. A contract valid in form but subject to cancellation when it causes damage or prejudice. C. A contract with no consent. D. A contract lacking cause.
4. Who may file an action for reformation under Article 1368? A. Only the judge who approved the contract. B. Either party if there was mutual mistake, or the injured party if unilateral mistake, including heirs or successors. C. Any third person. D. Only the injured party, never his heirs. 5. A guardian sells a ward's property worth $200,000 for only $140,000. What kind of contract is this? A. Void contract. B. Voidable contract. C. Resciscible contract. D. Unenforceable contract.
6. What is the main purpose of reformation of instruments under Article 1359? A. To annul the contract completely. B. To make the written document match the true agreement of the parties. C. To add new terms to the contract. D. To rescind a valid contract. Thank you for participating in our Q&A. Through your answers, we can see that the main points about our topic are now clearer. With that, we'll now move on to our closing remarks to officially end our report.
Summary: reformation of instruments is a legal remedy used when a written contract does not express the true intention of the parties due to mistake, fraud, accident, or unfair conduct. The contract itself is valid, but the document may be corrected by the courts to reflect what was really agreed upon. However, reformation is not allowed in wills, simple donations without conditions, or void contracts.
Resciscible contracts, on the other hand, are valid and effective, but may be set aside by law when they cause damage or unfairness to one of the parties or to third persons, such as minors, absentees, or creditors. Rescission is a subsidiary remedy, available only when no other legal action can repair the damage, and its effect is mutual restitution of what was exchanged.